I'd like to thank the members of the Advisory Council and the team of the International Nuremberg Principles Academy for inviting me to deliver the keynote address. In the past 2 decades or so, we saw in the West a surge of new studies of the Tokyo trial, whose positive impacts continue to reverberate to this day. The Tokyo International Military Tribunal, a reappraisal by Professor Neil Boyster and Professor Robert Cryer, and his companion sourcebook, Documents on the Tokyo International Military Tribunal, Charter, Indictment, and Judgments were among them, both published in 2008, marking the 60th anniversary of the judgment of the Tokyo Tribunal. The former was the first book-length legal analysis of the Tokyo trial ever to be produced in English by 2 scholars who are thoroughly versed in the relevant international criminal law literature. What was great about this book was, however, not only that it filled a gap in the existing scholarship relating to the Tokyo trial, but also that Professors Boyster and Cryer carried out extensive archival research to obtain internal memos of the members of the tribunal as well as the prosecution. They probed into the backstories of the making of the Tokyo trial by using these archival materials and at the same time explored the official part of the trial by using the transcripts of court proceedings. Furthermore, Professors Boyster and Cryer tapped into a wide range of secondary source materials, including the translation of a selection of works by Professor Awaya Kentaro, whom we historians of modern Japan revere to this day as the one who broke new ground in the studies of the Tokyo trial back in the late 1970s, and who has made singular and enduring contributions to defining the field. I will discuss Professor Awaya's scholarship and its legacy shortly. The significance of the latter publication by Professors Boyster and Cryer can hardly be understated either. This sourcebook contains in a single volume all of the essential documents of the Tokyo trial, namely the Charter of the Tribunal, the Rules of Procedure, the Bill of Indictment, the Majority Judgment, and all of the 5 separate concurring and dissenting opinions in a clean, highly readable, user-friendly format. The potential transformative effect of this sourcebook for researchers can be readily appreciated if one compares it with the 1977 publication of the Majority Judgment and 5 separate opinions compiled by the former Dutch member of the Tokyo Tribunal, BVA Rolling, or the trial record reproduced in the oversized multi-volume facsimile version compiled by Professor R. John Pritchard and his associates, published in the 1980s. These significant contributions by Professors Boyster and Cryer promise that the studies of the Tokyo trial will continue to grow in sophistication and in depth for the foreseeable future. The assessment of the Tokyo trial in the international community more broadly, meanwhile, underwent a marked change in these past 2 decades. It is my understanding that once upon a time, the Tokyo trial was virtually unknown in the West, except perhaps among a comparatively small group of Japan scholars and Japan specialists who acquired piecemeal knowledge about the Tokyo trial by way of limited English language publications, such as Professor Richard Minier's controversial text, Victor's Justice, published in 1971. But that is a matter of a time now past. As of today in 2018, the Tokyo trial, alongside the Nuremberg trials, has come to be recognized as the foundational event in the history of international criminal justice. The fact that a 70th anniversary event of the Tokyo judgment is held today at this very venue, the International Nuremberg Principles Academy, is a testament to the new ways in which the international community has come to understand the historical significance of the Tokyo trial and its legacy. The assessment of the Tokyo trial has transformed in recent years, arguably because of the growing global importance of international criminal justice mechanisms in the world today to end impunity for genocide, war crimes, crimes against humanity, and other types of massive human rights violations. Nuremberg and Tokyo are particularly credited for providing historical precedents for expressly recognizing and enforcing the principle of individual responsibility for international crimes. This principle has been reaffirmed in the ever-growing body of international criminal law literature since and is presently enshrined in the Rome Statute of the Permanent International Criminal Court at The Hague. If the Tokyo trial has come under spotlight in the international community relatively recently, the Tokyo trial has been a subject of intense inquiry for a very, very long time in Japan, since as far back as 1946, in other words, since the start of the Tokyo trial. As a result, there is now a 7-decade worth of Japanese language scholarship and publications on the Tokyo trial, and a highly knowledgeable reading audience across the Japanese archipelago. Now, let us take a moment to trace briefly the research trends on the Tokyo trial in Japan in those 7 decades. The ones who took the lead in engaging the Tokyo trial as the subject of scholarly inquiry in early years were mainly legal scholars and social scientists. The first generation of trial analysts, as one might call them, included the following legal luminaries: Judge Yokota Kisaburo, a preeminent professor of international law in Japan since the pre-war era, who was known for voicing criticism against the Japanese government's aggressive foreign policies in the 1930s, and who continued to retain his scholarly credentials in the post-war period to the point of being appointed to serve as president of the Japanese Supreme Court in the 1960s. Judge Dando Shigemitsu, a professor of criminal law whose body of scholarship on criminal law has defined that field in Japan throughout the post-war period, and who was also appointed to serve as a Supreme Court justice in the 1970s and 1980s. Kaino Michitaka, another preeminent professor of law who became a practicing lawyer in the 1960s to assist the socially and economically underprivileged population with various litigations. And Takayanagi Kenzo, a professor of Anglo-American law who served as the lead defense lawyer for the accused at the Tokyo trial. The assessments of the Tokyo trial by Yokota, Dando, Kaino, Takayanagi, and some other contemporary legal scholars and social scientists varied. However, one thing stands out in the body of scholarship that they generated, that is, the emergence of a general consensus among them that the Tokyo trial was a major positive development in the history of international law, and especially with regard to its recognition of the principle of individual responsibility for international crimes. There certainly were dissenting voices among them that challenged the validity of the principle of individual responsibility. Takayanagi, for one, insisted in his publications on the sanctity of the act of state doctrine and the state officials' immunity from criminal prosecution. Just as he had done, that is, when arguing on behalf of the accused at the Tokyo trial. It is worthy of our attention in any event that the Japanese legal luminaries, some 7 decades ago, articulated just the same assessments about the historical significance of the Tokyo trial as those made today in the post-Cold War international criminal justice context. That said, the body of scholarship thus generated by the first generation of trial analysts appears to have had limited circulation and ultimately failed to inspire its contemporaries to explore further the legal and jurisprudential legacies of the Tokyo trial. Yokota, Dando, Kaino, and others, meanwhile, moved on to pursue their respective careers as many pressing issues of real-life consequences in the Japanese state and society amid the post-war recovery called for their attention and professional services. What followed after the departure of the first generation of trial analysts to other fields and professional careers was a long phase of scholarly underproductivity in the studies of the Tokyo trial, from the early 1950s through the mid-1970s. However, this should not be construed as meaning that the Tokyo trial was forgotten. Lively debates on the historical significance of the Tokyo trial continue. That is, however, as a result of massive coordinated efforts by the critics of the Tokyo trial to discredit its legacy. Some of the Japanese patriots, including former colleagues and friends of the accused at the Tokyo trial, as well as the accused themselves, had voiced from early on the criticisms of Victor's justice in a show of detest that the Japanese wartime leaders, having already been defeated, were now being prosecuted and labeled as common criminals by the victorious Allied powers. Upon Japan's regaining of sovereignty in April 1952, they began to malign the Tokyo trial openly and carried out systematic attacks against its legacy. Their massive campaigns proved highly effective, thanks in large part to Justice Radha Binod Pal, the Indian member of the Tokyo Tribunal, around whom the critics of the Tokyo trial rallied. As you know, Justice Pal was one of the 3 dissenting justices at Tokyo. He produced a long and winded dissenting opinion in which he concluded that, and I quote, "Each and every one of the accused must be found not guilty of each and every one of the charges in the indictment," end of quote. Justice Pal visited Japan 3 times in the 1950s and the 1960s upon invitation from the sympathizers of the convicted Japanese war criminals. During his visits, he promoted his dissenting opinion as the judgment of the Tokyo Tribunal, while reportedly castigating the majority judgment by characterizing it as nothing but the victorious Allied powers' propaganda piece to make the Japanese people accept defeatist mentalities. The controversial role that Justice Pal played in defining the Japanese perceptions of the Tokyo trial will likely be a subject of discussion during this conference, I'm quite sure. For now, I limit myself to bring to your attention this particular historical problem. The studies of the Tokyo trial in Japan took on a new life since the late 1970s, when Professor Awaya Kentaro, a preeminent historian of modern Japan teaching at Rikyo University in Tokyo, unearthed at the US National Archives the recently declassified voluminous internal memos of the International Prosecution Section at the Tokyo trial. He began utilizing these massive archival materials to produce numerous books, articles, and source books on the Tokyo trial to share with the Japanese public his findings on the hitherto unknown activities of the prosecution. Professor Awaya did not limit himself to exploring the archives in the United States, but he also visited Australia, where he unearthed additional important archival documents concerning the Allied powers' planning and preparation for the Tokyo trial. Some of the questions Professor Awaya addressed by using the new sources included the following. 1, how did the prosecution select the prospective accused? 2, how did the prosecution determine the prosecutorial priorities? 3, how did the prosecution go about collecting evidence and developing the charges? 4, what kinds of cooperation did the prosecution receive from the Japanese accused and witnesses? 5, how did the Allied powers determine their policy regarding the handling of the Japanese Emperor Hirohito as a war criminal? And 6, what were the long-term consequences of the Allied policy decision not to try Emperor Hirohito for our understanding of justice and accountability? Both the Japanese academia and the knowledge-thirsty Japanese public welcome with open arms the new findings by Professor Awaya that address these and other important historical questions. Eventually, the body of scholarship Professor Awaya generated came to constitute the bedrock of the Japanese knowledge of the Tokyo trial. Furthermore, Professor Awaya's research greatly energized the studies of the Tokyo trial as a field, and new lines of research were pursued by the younger generation of historians in the 1990s and the 2000s. One of the greatest scholarly accomplishments to arise in those decades was Professor Higurashi Yoshinobu's monograph titled, and I read in Japanese, 東京裁判の国際関係、国際政治における権力と規範, and in English translation, International Relations of the Tokyo Trial, Power and Norms in International Politics. This was published in 2002. As the title suggests, this book, containing 708 pages in all, treats the Tokyo trial as a microcosm of international politics of the post-World War II world. Professor Higurashi illuminates in this mammoth monograph, by using voluminous archival materials, the fierce competition, rivalry, and partnership among the 11 participating Allied powers in the redefinition of the post-war world order by way of the Tokyo trial. This publication emulated Professor Awaya's source analysis and research methods to some degree. However, Professor Higurashi distinguished himself in that he explored the archives of the former Allied powers far more systematically, methodically, and exhaustively than Professor Awaya had done. It is no exaggeration to say that with the publication of Professor Higurashi's work, the studies of the Tokyo trial as a field reached a point of maturity. Now, given the tremendous research accomplishments made in Japan since 1946, and given the emergence of new scholarly works on the Tokyo trial elsewhere in recent decades, might we say that the studies of the Tokyo trial have reached a point of saturation? I would answer this question negatively, especially where it concerns the legal analysis of the Tokyo trial. It is true that thanks to the ever-increasing participation of the scholars of international law in this field, we have come to have a far better understanding of the history and the present-day relevance of the Tokyo trial. However, the sheer size of the trial record, the requirement of the researcher's proficiency, at least in two languages, that is in Japanese and English, and the highly interdisciplinary nature of the Tokyo trial as a subject of inquiry continue to pose challenges as we seek to generate an authoritative and comprehensive assessment of the legal, historical, and jurisprudential legacies of the Tokyo trial. As of today, there still are a number of important research questions that need to be addressed. Let me, for now, suggest three sets of research questions, or research areas, rather, for our consideration based on the outcomes of collaborative research that Professor David Cohen of Stanford University and myself have recently carried out. First, we may readily agree today that the Tokyo trial provided an important historical precedent for the recognition and enforcement of the principle of individual responsibility for international crimes. But we are yet to acquire a definitive understanding as to what sorts of theories of liability exactly were introduced at the Tokyo trial, and how the theories of liability thus introduced were applied to examine the evidence against the individual accused. Consider this: we know that General Matsui, former commander of the Central China Area Army, was convicted of war crimes at Tokyo relating to mass atrocity in Nanjing on grounds of command responsibility. But what about the other accused? The vast majority of accused at the Tokyo trial had held non-military high-level government positions over the course of the war, such as those in the cabinet, the Privy Council, the Ministry of the Imperial Household, and various other ministries that constituted the Japanese government bureaucracy. Presumably, the doctrine of command responsibility did not apply to these individuals since they fell outside the military chain of command and were not vested with command authority. Second, some of us may be familiar with the fact that the prosecution drew upon the 1907 Hague Conventions and the 1929 Geneva Conventions to advance what one might call a theory of government officials' responsibility, and that the prosecution sought to establish the link between the former high officials of the wartime Japanese government and war crimes by applying that theory. However, it is virtually unknown in the existing scholarship that not only did the prosecution advance the theory of government officials' responsibility, but also did it take upon itself the burden of proving the unique structure and complex workings of the emperor-centered wartime Japanese government. The prosecution did so apparently because it alleged in the indictment that each of the defendants, and I quote, used the power and prestige of the position which he held and his personal influence in such a manner that he promoted and carried out the offenses set out in each count of this indictment, end of quote. This allegation would naturally raise the question as to what sort of power and prestige, in the first place, were vested in the various positions held by the individual accused. As if to address this question, the prosecution presented from the start of the Tokyo trial such evidence that would help the judges acquaint themselves with the organization of the pre-war and wartime Japanese government and figure out how the power of government was distributed, both by law and by custom. The evidence presented by the prosecution brought out that there were three essential layers in the organization of the Japanese government. They were namely, 1, the formal structure of the government as defined by the Japanese laws. 2, informal government institutions that were not expressly recognized by the Japanese laws but developed by custom, and which exercised tremendous influence over the actual workings of the formal structure of the government. And 3, a superstructure of the government, which grew in the 1930s and the 1940s to meet the exigencies of the war, and which made the policy decisions over and above the formal structure of the government. These 3 elements were meshed over time to form a highly complex structure and workings of the Japanese government, according to the prosecution, and by extension, a highly complex system of the distribution of government power and prestige. The defense did not dispute the validity of the prosecution's case in this regard. Third, as stated earlier, Professors Boyster and Cryer produced 10 years ago a model of the legal analysis of the Tokyo trial. However, we are yet to see an exhaustive study of the majority judgment and the 5 separate concurring and dissenting opinions in a manner to gain a comprehensive understanding of the jurisprudence arising from these varied opinions. Speaking of jurisprudence, moreover, the existing historical literature fails to offer much insight either into the substance of a draft judgment that Justice Sir William Webb, the Australian member and the president of the Tokyo Tribunal, had produced during the Tokyo trial. This draft judgment, some 657 pages in typescript, was never made public because Justice Webb was unable to gain support from the 7 majority justices and was compelled to withdraw it. The existence of Justice Webb's draft judgment was known among the researchers of the Tokyo trial for a few decades by now. However, the views expressed there drew limited attention, seemingly because of the general reputation of Webb as an ill-tempered and erratic justice whose grasp of the law may have been fair but not superb. A close study of the draft judgment indicates, however, that Webb, in fact, was a judge of great competence and intellectual capacity. He provided, in his draft judgment, a detailed examination of the relevant evidence against each of the 25 accused and reached a well-reasoned decision on each individual's verdict. Moreover, Justice Webb articulated in the draft judgment the applicable theories of liability clearly and applied them consistently when examining the evidence against the individual accused. Our study shows that the majority, by contrast, did neither. The majority's analysis of the relevant evidence against the individual accused was skimpy and spotty in most part. The sheer fact that the majority spent for the analysis of individual cases merely 28 pages out of 557 printed pages in the Boyster and Cryer sourcebook, or 5% of the whole majority judgment, is indicative of the skimpiness. By comparison, Justice Webb spent some 374 pages out of the 657-page typescript. In other words, about 59% of the whole of the draft judgment. The majority did poorly on theoretical issues of individual responsibility too. Unlike Justice Webb, the majority articulated the theories of liability inconsistently and applied those inconsistent theories of liability inconsistently. So it's a little bit complicated. Two of the dissenting justices, Justice Powell and Justice Rawling, figure poorly too when their dissenting opinions are compared with Justice Webb's draft judgment. Justice Powell indicated in his dissenting opinion general indifference to the idea of individual responsibility as a legal principle, and instead insisted on the sanctity of the act of state doctrine and immunity of government officials from criminal prosecution, so that he could reach the conclusion that, and I quote again, each and every one of the accused must be found not guilty of each and every one of the charges in the indictment, end of quote. Justice Rawling was the polar opposite of Justice Powell in that he considered most of the accused guilty of various charges. However, Justice Rawling took exception with certain categories of individuals, such as former foreign ministers, by positing that the statesman may commit an error when making policy decisions on behalf of the state, and that such an error ought to be construed as, and I quote, a non-criminal error in judgment, end of quote. He accordingly recommended to give such individuals what amounted to be the blanket immunity from criminal prosecution. These are some of the findings in comparative studies of the Webb draft judgment with the majority and separate opinions. As we mark at this conference the 70th anniversary of the Tokyo judgment, I look forward to sharing with our colleagues these and other research questions, findings, and problems so that we will be able to identify the areas of collaboration between historians and legal scholars for the future advancement of the studies of the Tokyo trial. Thank you very much.